Good day, I am Rodely Galang from the Scream 4 Echo, and I will discuss the different justifications of punishment. The theories or justification of punishment vary from one stage of civilization to another. The most common justification of a punishment are retribution, expiation or atonement, deterrence, protection, and reformation. Retribution in primitive times, punishment of the transgressors was carried out in the form of personal vengeance, since there were no written laws and no courts. The victim of a crime was allowed to obtain his redress in the way he saw fit. Later, an attempt was made to limit the retaliation to the degree of injury inflicted. Thus, the philosophy of an eye for an eye evolved. For example, the retribution for a person who stole money would be to pay the money back. Whereas retribution for a person who committed murder would be to either receive the death penalty of life in prison. Either option takes a life for a life. Retribution prevents future crime by removing the desire for personal avengement in the form of assault, battery, and criminal homicide, for example. Against the defendant, when victims or society discover that defendant has been adequately punished for a crime, they achieve a certain satisfaction that our criminal procedure is working effectively, which enhance faith in law enforcement and our government. Expiation or atonement, which when punishment is exacted visibly or publicly for the purpose of appeasing the social group, the element of expiation is present. Punishing the offender gives the community a sense of its moral superiority, an assurance that virtue is rewarded after all. In most modern countries, the corporal punishment has been abolished, and the application of punishment has tended to be withdrawn from the public eye. Deterrence. Cesar Beccaria argued that punishment should not be to torture the criminal or to undo the crime. He advocated the theory that a punishment should have only the degree of severity that is sufficient to deter others. In England during the 18th century, pickpocketing was one of the 50 offenses punishable by hanging. The concept of deterrence presumes that the person thinks before he acts and that all he has to do is think the consequences, and then he will be deterred. But offenders commit crimes without a fear of punishment foremost in their minds. Some types of offenders, particularly first-time offenders, can be stigmatized by the lightest form of punishment. Deterrence prevents future crime by frightening the defendant or the public. The two types of deterrence are specific and general deterrence. Specific deterrence applies to an individual defendant. When the government punishes an individual defendant, he or she is theoretically less likely to commit another crime because of fear of another similar or worse punishment. General deterrence applies to the public large. When the public learns of an individual defendant's punishment, the public is theoretically less likely to commit a crime because of fear of the punishment the defendants experience. When the public learns, for example, that an individual defendant was severely punished by a sentence of life in prison or the death penalty, this knowledge can inspire a deep fear of criminal prosecution. Protection. People believe that by putting the offender in prison, society is protected from his further criminal depredations. But how effective is imprisonment as a means of protecting the community against crime? Even if all convicted offenders were kept in prison for life, the other 96.5% who are at large will continue to plague society. Prison as an end to punishment is not tenable because prisoners are released after a short period of confinement. Reformation. Inmates are held in prison for a relatively short period of time, from 3 to 5 years. Advocates argue that society's interests are best served if the purpose of imprisonment is to reform or rehabilitate the prisoner. Some prisoners are reformed, but about 50% relapse. Failure to reform prisoners may be due to poor administration of the reformatory program. There are other purposes of justification of punishment. The first one is incapacitation. Incapacitation prevents future crime by removing the defendant from society. Examples of incapacitation are incarceration, house arrest, or execution pursuant to the death penalty. The second one is rehabilitation. Rehabilitation prevents future crime by altering a defendant's behavior. Examples of rehabilitation include educational and vocational programs, treatment, center placement, and counseling. The court can combine rehabilitation with incarceration or with probation or parole. In some states, for examples, non-violent drug offenders must participate in rehabilitation in combination with probation, rather than submitting to incarceration. This lightens the load of jails and prisons while lowering recidivism, which means reoffending. The next one is restitution. Restitution prevents future crime by punishing the defendant financially. Restitution is when the court orders the criminal defendant to pay the victim for any harm and resembles a civil litigation damages award. Restitution can be for physical injuries, loss of property or money, and rarely emotional distress. It can also be a fine that covers some of the costs of criminal prosecution and punishment.